There's a new case on the Fair Credit Reporting Act from the U.S. Supreme Court. We're going to talk about it in detail today and how it helps consumers out. Hi, this is consumer protection attorney Bill Clant. I've helped thousands of people deal with inaccurate credit reporting, bad background checks, debt collection harassment, and all sorts of other consumer-related matters. In today's video, we're talking about the new USDA versus Kirtz decision from the U.S. Supreme Court. It says that there is no governmental immunity under the Fair Credit Reporting Act. In other words, you can sue the government when they mess up your credit report. Let's take a look at this important decision now. Okay, here it is said again. Department of Agriculture, Rural Development, Rural Housing Service is the petitioner, the ones who appealed it, versus Reginald Kirtz. Okay, so let's take a look at what the court says here. Now, this opinion was authored by Justice Gorsuch, one of the more conservative members of the court, and he starts off strong here. He says, a credit report can determine everything from whether a person can secure a credit card, purchase a home, win a new job, or start a small business. That covers just about everything that people want to do that is affected by their credit report. The question we face is whether one of the nation's largest lenders, the federal government, is also susceptible to suit when it supplies false information, or whether it may invoke sovereign immunity to avoid liability. So sovereign immunity is the idea that the government is not liable to its citizens for its mistakes, its errors, its harm to its citizens. This is a well-known and well-documented policy. For instance, if you get hit by a government vehicle, then you have to give notice within a certain amount of time, or those claims cannot be brought against the government. There's all kinds of ways that the government limits its liability or eliminates its liability under the law, and those are generally referred to as sovereign immunity. And here the government is saying that it is immune from lawsuits under the Fair Credit Reporting Act. It can basically says it can, its argument is it can disseminate false information about everybody and nobody can do anything about it, which is kind of an absurd position to take. And we'll get into that a little bit later. According to Mr. Kirtz, he repaid his loan in full by mid-2018. Despite this, the USDA reported him as past due to TransUnion. These misrepresentations damaged his credit score and threatened his ability to secure future loans at an affordable rate. Mr. Kirtz says the U.S. failed to take any action to investigate or correct its records, so he eventually decided to sue them under the Fair Credit Reporting Act. The Fair Credit Reporting Act defines the term person broadly to mean any individual, partnership, corporation, trust, estate, cooperative, association, government, or government subdivision or agency or other entity. So it's got a broad definition. You can kind of see where the court's going with this. Okay, according to the complaint, the USDA furnished information to TransUnion. The agency had noticed the information it supplied was false. That false information impaired Mr. Kirtz's ability to access affordable credit. Okay. So Kirtz files his lawsuit. What does the USDA do? They move to dismiss it. They say pointed to the court's precedents holding that as a sovereign, the federal government enjoys immunity from suits for money damages unless Congress waives that immunity. So the district court sided with the USDA, but the Third Circuit reversed. Okay, so there are 93 or 94 U.S. district courts, the trial court level, the lowest level of federal court. And then there are 13 appellate courts, and then there's one Supreme Court. So in this case, the trial court dismissed it. Mr. Kirtz appealed it to the Third Circuit Court of Appeals, and the Third Circuit Court of Appeals said, trial court, you got it wrong. This should not have been dismissed. This should have been immunity does not apply in this situation, is basically what the Third Circuit said. And then this was appealed by the USDA to the Supreme Court. Okay, so the question whether Mr. Kirtz may sue the federal government holds significance for many. Now, here the Supreme Court talks about how bad the credit reporting industry is. A 2021 study cited by the Consumer Financial Protection Bureau found that over 34% of consumers surveyed were able to identify at least one error in their credit reports. This agrees with FTC studies. The FTC has said that 20% of credit reports contain a significant error. 5% contain an error significant enough to cause you to be turned down for credit or pay too much for credit. So 34% is higher than what the Federal Trade Commission was reporting a decade ago, but it's expected. Okay, and so why is it important? Well, these days too, federal agencies are among the largest furnishers of credit information to consumer reporting agencies. Federal government furnishes tons of information to the credit bureaus, and they are part of this 34%. So it's important for them to get it right because, again, how we started off here, credit is important to your ability to make money, to get credit, to get a job, all kinds of things. Okay, so now the court analyzes what the circuits are doing. Now, sometimes the circuits have splits. One or two circuits will hold on an issue one way, other circuits will hold another way. And here, the court explains that like the Third Circuit, the Seventh and the D.C. circuits have held that the FCRA authorizes suits against government agencies no less than it does private lenders. So no immunity. The Fourth and the Ninth circuits, by contrast, have held that sovereign immunity bars consumer suits against federal agencies. So one of the jobs of the Supreme Court is to resolve these circuit splits. This is not uncommon that a group of circuit courts will hold one way and another group of circuit courts will hold another way. And so then other circuits aren't sure what to do. Trial courts can look at that are in a circuit that hadn't held on this issue, can go either way on this, and it creates some disarray in the law. And so one of the jobs of the Supreme Court is to make decisions that eliminate these circuit splits. And that's what they proceed to do here. Okay, they go and they talk about sovereign immunity here in part 2 of the opinion. And they summarize their thinking by saying, a waiver of sovereign immunity must be unmistakably clear in the language of the statute. And it goes through more analysis here. And they end up talking about all the principles they need to follow in determining whether there is sovereign immunity and whether there's a waiver of sovereign immunity. And they say, guided by these principles, we think the Third Circuit reached the right decision in the case. The Fair Credit Reporting Act effects a clear waiver of sovereign immunity through a series of statutory directions, no less than those we encountered in Kimmel, another case. Congress has explicitly permitted consumer claims for damages against the government. Okay, so the only question we face is whether those provisions speak clearly to the government's liability. Because they do, that is the end of the matter. And so in 7 pages here, let's see, this opinion starts at the bottom of page 3. So in about 4 pages here, Justice Gorsuch destroys the idea that there is any sovereign immunity under the Fair Credit Reporting Act. And this is great for consumers. What does this mean? This means that you can sue the federal government if they mess up your credit report. VA loans, Department of Education loans, student loans, these FDA loans. And so the next part of the opinion, Justice Gorsuch goes through and the court goes through other arguments the government makes. And for the sake of clarity and not getting tedious about this, and for sake of understanding, I'm going to go over this very briefly. So what matters is whether Congress has authorized a waiver of sovereign immunity is clearly discernible from the sum total of its work. And they say that the Fair Credit Reporting Act does. I think there's one more part of this that I highlighted. Let me see. Yes. Okay, so they're saying that the USDA, the government's arguing that there's so many overlaps, it's so much going on. And here's what he says. I think this is applicable to a lot of folks. Nor is the need to juggle multiple and sometimes overlapping obligations an unusual feature of contemporary American life for the government any more than it is for the governed. So he's saying that there's so many laws, there's so many overlapping legal obligations, and there's so much to understand in modern American life for consumers as well as the government. Recognize this fact and mindful our role is to apply the law and not rewrite it. We approach federal statutes touching on the same topic with a strong presumption they can coexist harmoniously. Okay, so there you have it. That is the Supreme Court deciding that the federal government does not have immunity from Fair Credit Reporting Act lawsuits. The federal government is held to the same standard as other furnishers, as private lenders. So if you have an error in your credit report that is a result of the federal government, whether it's the Department of Education, whether it's the USDA, whether it's the VA, or any other government lender, you can now take action. If you have that kind of problem, give us a call. We're ready to take on the biggest banks, the biggest credit reporting agencies, and the federal government. Thanks for watching this video.